All right, good evening, everybody. It's 6 o'clock, so let's get started. Thank you all for joining us for our public lecture. Judge Essex, we need you over here. It's a delight to be able to welcome Judge Essex, who serves on our advisory board and is probably the most well-known figure from the ITC. I was just telling him over lunch today. Every time I read something about the ITC, it's Judge Essex says this, or Judge Essex held this. And then you forget that the ITC actually has a bunch of other ALJs, but he has since now joined Hogan Lovells, travels the world. Can ask him more about that afterwards. Just came back actually from Korea. So it's been not just a trip, but a long distance trip for him. And we won't ask him which time zone he's in. For those of you who came in, you should have received our latest newsletter, as well as hot off the press, our detailed program for our 63rd annual IP conference, November 1st. Be there or be square, as they say. And then following from that, Monday and Tuesday, we're having our International IP Seminar, where we have representatives from the World IP Organization. We have folks from Europe, in-house counsel, local counsel, foreign counsel. Great opportunity to meet people, learn about IP practice from outside of the US. I just want also to thank our volunteers, Alex, who is EIC's, Ripple's EIC, Emily, who is there behind the camera, as well as Natalie, who is helping with the registration, and of course, Carl Cirilla. So these are the people that really make the magic happen, and without them, we would have a lot of difficulty offering the many programs that we do throughout the year. So without further ado, I'm going to hand the floor first to Kyle to talk about this new innovation that we are introducing this year. It's called Pigeonhole. And then Alex will introduce Judge Essex. So Kyle.
Hi, my name is Kyle Cirilla. I'm the IP Law Fellow here, and I just wanted to talk to you a little bit about this today. You get to be some of the lucky people that are guinea pigs for your first event that we're using this feature. Basically, if you have your smartphone with you or have your laptop with you, if you use your browser, just go to www.pigeonhole.at and enter this code. You don't need to log in, you don't need to put your email in there or anything like that. You can ask a question anytime during the lecture, and it's going to go into a page that we're going to post at the end during our Q&A section, and then we're going to start with those questions. And the nice thing about this is if you and someone else have the same question, and you see it's already in there once you posted it, you can vote questions up, and then it also allows us to kind of see sort of what are the reactions of the audience that we just experienced as lecture together. And it also lets you not forget that question. You know that there's so many times where you're like, oh, I have a question right now, and then by the time you get to the end of something, you might forget. So I recommend that if you have a browser handy right now, to type this in, and then if you happen to have a question during Judge Essex's lecture, to type it in right then, and then you can kind of put that down and enjoy the lecture. Now I'm going to hand it over to Alex Carana, our Ripple's editor-in-chief, who is going to give us our introduction for Judge Essex.
Thank you. As Kyle and Professor Lin mentioned, my name is Alex Carana, and I'm editor-in-chief of Ripple. It's a review of intellectual property law here at UIC John Marshall. And just a little bit about Ripple first. Ripple publishes numerous articles related to trademarks, copyrights, patents, and trade secrets, as well as antitrust. And it's comprised of top students here at UIC John Marshall who are interested in intellectual property. And over the years, Ripple has been cited as persuasive authority in the federal circuit, as well as parties petitioning to the Supreme Court for writ of cert. Some prominent judges that we have published articles from are Supreme Court Justice John Paul Stevens, Federal Circuit Chief Judge Paul Mitchell, Judge Richard Lynn, Federal Circuit, and Judge Richard Posner of the Seventh Circuit here. And recently, Ripple published an article by IP practitioners Sherry Knowles and Anthony Prosser based on patent law section 101, and they had the opportunity to cite their article the House Judiciary Committee, Subcommittee for Intellectual Property, just this past summer. And so these articles have allowed Ripple to maintain a top 15 ranking in Google Scholars for technology law journals. And just this past year, our articles have been downloaded over 50,000 times internationally. So Ripple will be publishing our first issue this month, so please keep an eye out. And if you would like to submit an article for consideration for a spring issue, please email ripple@jmls.edu or visit our website. So moving on, I'd like to introduce our speaker for tonight, Judge Theodore Essex. Judge Essex is currently senior counsel at Hogan Lovells in Washington, D.C., and is a lecturer at George Washington University Law School. He also serves on the advisory board of the Center of Intellectual Property Law, Information and Privacy Law here at UIC John Marshall. And he'll also be returning as a panelist for the IP event on November 1st. Prior to his current role, he served as an International Trade Commission judge for about a decade, and he has a wealth of knowledge of intellectual property internationally and has been hailed as an unofficial ambassador for lawyers and judges throughout the United States, Asia, and Europe. He's the only individual to have served as president for both the Pauline Newman and Giles S. Rich American Inns of Court, which focus on the Court of Appeals for the Federal Circuit. And he has also co-authored a chapter on ITC mediation for the American Bar Association Alternative Dispute Resolution. He earned his degree from Miami University and his Juris Doctorate from the Ohio State University Law School. And before joining the ITC, he was a trial lawyer for the U.S. Air Force and a public defender in the state of Ohio. So today he'll be sharing us his insights on the ITC, and if you could please join me in welcoming Judge Essex.
Thank you very much. Let me have a couple of very quick preliminary comments. I always had to give this disclaimer when I was on the bench, and that is my remarks are my own, and I don't speak for the commission or anyone else. Give me a certain amount of freedom because I like to try to help it along. Sometimes you have to say things that they don't necessarily want you to hear to do that. I appreciate the introduction, and I also want to thank all of you for coming out on a Tuesday. You probably could have found something else to do this evening. I appreciate that you're here with me, and I want to give each of you thanks for that. I want to thank Daryl and the rest here. Just a quick, for the people in the room, how many have heard of the ITC or have had any business with it or know anything about it? A little bit, that's good. All right, we are a part of the executive branch, oddly enough, and we are about 300 and some odd people at the ITC. It does essentially three things. The first one is we have a whole bunch of economists, and they do a whole bunch of reports. They're politically neutral and highly respected in Washington. So they will write for congressmen or others that have a need for a particular economic report on tariffs, how things are going around the world. The second thing they do is the ITC under Title VII has an anti-dumping function. And the administrative law judges don't have anything to do with that. The commissioners see those cases themselves personally. They have a large room, all six of them sit up there, there's 6 commissioners, and they will handle those cases. You can almost always tell when such a case is going on at the ITC because there'll be a number of union representatives that like to have a picture taken right at our sign. So when I was walking in, if I saw a bunch of people that said United Rubber Workers and they're on the sign, oh, we must have a Title VII case. Then the last thing we do are 337 cases. And I want to go on briefly. That is Title 19 USC 1337. And it started out purely as a tariff recommendation commission. It's over 100 years old in that form. It started. And we went on from doing tariffs to changing the laws and so forth until in about 1974, the commission changed where we could exclude products from coming into the United States, and the president could then go up and down. We'll get more into that later. But so the commission's been around a long time. we're one of the three primary functions that we call the 337 function. I want to go, this is the building we're in. Normally it wouldn't be important, but it is for this reason. One of the appeals of the International Trade Commission for businesses that are disputing and having 337 cases is we at the Commission handle confidential business information very, very carefully and very seriously. And we only hold our sessions, our hearings in this building, mainly so we can control confidential business information. In the building on the first 2 floors are 3 different courtrooms. People ask me sometimes if they could, if they're in Washington, go to a hearing, and the answer is yes, you can, but don't bother doing it. And the reason is every time the information is confidential, think that can be about sales records, not the patents themselves, they're never confidential, but anything that has to do with the businesses, they won't allow you to stay in there unless you're on the confidential order that's signed at the beginning. So, you know, all the guests get to go out whenever anything happens. And then when it's dull again, you come back in. So we have 3 courtrooms and they're all there in this building. It's in Washington, D.C. This slide tells you how busy we've gotten since we really opened for business back in the last century. The figure on 19 had but they come together, so the commissioners have to work through surrogates, basically. It's a strange situation, generally. The other thing about the commission I always found interesting is almost always in federal government, the Department of Justice represents a government agency if it goes through the court system, because intellectual property is considered a specific type of law that's a specialty in that. Our attorneys from the General Counsel's Office represent the United States when we go to the Court of Appeals for Federal Circuit. We don't have DOJ attorneys in that. Whether that's good or bad, depends whether you're asking one of our General Counsel or a DOJ attorney. They would like to do this. This other thing, most of the commissioners come from economic backgrounds on Capitol Hill. We had one, Scott Keefe, who also is a professor at GW, but she's the only commissioner that ever had a patent background. So these people mainly are trade people. Here's an eye test for all of you that are younger than me, which is everyone in the room. The commission, the chairman, this office is going to be important. This is the Office of Unfair Import Investigations. I'll tell you more about that later. The Office of Administrative Law Judges, right now they are authorized 6, and they actually have 6. So they're in top form. Commission is also authorized 6. They have 5. This is considered, and a rarity in Washington, this truly seems to be a nonpartisan commission. By law, there can be no more than 3 members from either the major political parties, Republicans and Democrats. Right now, there are 3 Democrats, 2 Republicans, and 1 vacancy. People have asked me when to expect to fill the vacancy, and the short answer is it's not on anybody's priority. Traditionally, we function without commissioners. We function with commissioners whose terms have been up, and nothing seems to change very much. So I don't know when they're going to fill the vacancy. I suspect with the presidential election coming up in, any time in a year or so, they may not get to it for that, and we'll function with 5 commissioners, and quite frankly, nobody in Washington seems to care. All right, and I mentioned this earlier, that our own general counsel goes to the Court of Appeals for Federal Circuit. I'll throw something else interesting in here on this appeal. The party that lost does the appeal, which is pretty basic, but they don't appeal against the other party. They don't fight out the next level. The ITC opinion is the thing that's challenged. So the party that wins is not technically, they must intervene at the level of the Court of Appeals for Federal Circuit. So you have the losing party, whoever that may be, versus the ITC. And the intervening party does it traditionally, and depending who the judges are at the Court of Appeals Federal Circuit, the ITC attorneys may get more or less time. It just depends on the particular case. But it's I'm one of the language policemen, and this is truly unique in the sense that I don't know of any agency that has a similar setup where they appeal it and they have their own attorneys do so, and the winning party to defend its opinion or defend its victory has to intervene. It just is a very different sort of setup. This is what I used to do, the ITC judges. There are 6 of us that I mentioned. Now, when I got there, each judge had 1 attorney, but now they have 2. People ask if we sit around and talk about our cases. The answer is no, because these are very, very large cases. Generally speaking, hearings will be 5 to 10 days as a general rule. And without hearing the witness, you can't really, if you're talking to another judge, they didn't hear the case, they don't have the facts in hand, and generally speaking, they're too busy to care about your cases. So we didn't consult a whole lot. When I got there, we had not had a judge that actually had a patent background. We now do so. Judge Clark Cheney, who actually was a patent attorney before he came on, he was hired initially in the office of the judges. He was hired by me. He went on to go to the general counsel's office, and he's come back as a judge. Judge Elliott is the newest judge. He also had a patent background. And then Judge Shaw was a clerk at our offices for over 20 years. And then he went on to become a judge. So we have 3 judges now who actually have a patent background, which is the first for the ITC. One of the interesting things, the commissioners, because they can, this is where you get my personal opinion in it, that they require the judge to write on every potential issue that could come up, because they don't have to do it, which means the judge's opinions will be very long. And you say, well, but if this case is settled on obviousness, then write up obviousness, you got 17 pages, you're done. They want us to do everything. So usually the opinions are very long and they will cover every issue, because if the commission decides, well, he's wrong on obviousness, let's use the rest of his opinion, they can do so. We've done a lot of things worldwide. When I was with the commission, I personally thought that no one has to file the ITC. It's a voluntary act. And so I wanted people to know about us, to know that we were fair, and we have hosted judges from Supreme Court in different countries. I had the Supreme Court judge from Korea and one of the regional judges. I've had Japanese judges and things hosted in my office and that. And the purpose was to demonstrate what I thought, that we will handle things fairly. We will give everyone an even hearing, and it's a good place for their cases to be heard. And I think by and large we've made some progress with we're doing that. You wonder, what does it take to get the ITC? It's very difficult to say particular, but generally speaking, there are 3 things, 2 of which are very easy. You have to have a U.S. intellectual property interest. Trade secret, normally patent. Our cases run about 96% of them involve U.S. patents. And it's very easy. They have the number, and then they have it or they don't. The second thing is there has to be an import of an infringing product or allegedly infringing product. That's pretty easy these days, because almost everything is made in China, and last time I looked, they have to import when they bring something in from China, so the importation is easy. The last thing, and this is something, if someone ever takes you aside in the alley and says, I can show you what domestic industry means, it'll be easy, they're lying to you, because it used to be easy when I was a young judge. The commission has changed that, we'll go over it, but domestic industry is the third thing, and it can be easy in one sense. Take any big smokestack industry, like I think Caterpillar's headquartered here in Illinois, is it not? So if Caterpillar is filing, they've got a plant, and they've got smoke building out of stacks, and that is very easy. That's a domestic industry. Plant and equipment. They have to have machines to build stuff. That's easy. That's number 1. Number 2 is capital and labor. So if something is made abroad, but it's supported here in the United States. The best example I ever had was a case of mine, and the plaintiffs knew me well, so they took all their evidence, the videotape evidence was in a Budweiser brewery. It's because they knew that would keep my attention anyway, and it was for the conveyor belts that whiz the cases of beer by, and had me mesmerized for about 10 minutes. But they were made abroad, but they're installed and maintained by labor here in the United States. So they had capital and labor, easy. And the last one is licensing. We'll talk about that a little bit later. I'm going to skip it because God knows what licensing means these days at the ITC, but that would be the third one. So out of the three things, there's plant and equipment, capital and labor, and licensing. This is another part that I really believe is unique to the ITC. Office of Unfair Import Investigations. They are an interesting hybrid. When you want to file, let's say you're going to represent a complaint, you got a job, that's congratulations. And you're drafting a complaint for the ITC, these people will help you. And you want to go to them, you want their help for no other reason than after they tell you your complaint's okay, they're going to turn around and advise the commissioners. So if you ignore them, or you don't go to them, you're hurting yourself. So I don't know any place that has attorneys that will advise the commission, the head of the agency, but then they can turn around and they will be a full participant. So we will have a hearing. They're not assigned to every case, but in some hearings you'll have a complainant, respondent, and OUII, and they're supposed to, in the course of that hearing, look after the public interest. Again, they are parties. They have the same rights to discovery and so forth as the complaints or respondents. But beforehand, they talk to the commission. Now, they're bound by the same rules. When the case is started and the commission voted to start a case in that, then they cannot talk to the judge and do anything that another party cannot. But I don't know any other agency that has such a group. And I just throw this in because, again, to support the agency, there are those that try to get the staff on their side a lot because I think the staff has advantages because they're part of the agency. We see them every day and that. Generally speaking, the judge is not any more reluctant to go against them, they say, than anyone else. But it depends. Some of the staff attorneys are very good. Some of them are not as good as others. There used to be one staff attorney, and this is a secret, by the way, but my nickname for this attorney was Me Too, because whatever the complainant said, they were going to say the exact same thing. Now, it's all right for the same position, and many staff attorneys have the same position, but they have different reasons and different support. This one particular one never did. She just said whatever the other side said. So sometimes they can be very influential. We've had some very good ones. Dean Whelan, the Dean of Intellectual Property at George Washington, started out his career as a staff attorney at the ITC. So we've had some very successful people from there. But they are unique and they do function differently. They will draft briefs and so forth like the other parties do, and they can be very influential. The one thing they can do, again, if you're attorney for the party, they have the best collection of motions and what judges have ruled on motions from the ITC of any place in the world. So if you're thinking about doing a motion, generally speaking, the big one we used to get where there are fights is something called source code. And those of you in computers, people try to explain this to me, they've been unsuccessful, but source code apparently is very important to parties. And parties want to have a number of conditions on it, and the staff would come and say the judge will never go along with that. Here are the last 5 cases, and they've been very helpful, although the judges often don't know they're helpful 2 years later, because they can't come up and tell you, well, you know what those idiots were going to do? They were going to do this, and then they didn't. So they can be very helpful. They can tell you what has happened in the past, and if you don't use them as a resource, you're hurting yourself. All right, we'll go through this somewhat quickly. The Trump administration, I don't think is going to have a large effect on 337. We'll go to that later. We just had 2 new commissioners appointed. Randolph Stan is a fellow from Virginia, and Amy Carpel came out of the U.S. Trade Office. We don't expect anything really different from them. Mention one of the next one's going there. The Commissioner Jason Kearns is relatively new, and he was a Democrat, so he's one of the 3 Democrats, Commissioner Stan, Republican convention. Basically on his whole background, the same thing with Ms. Cargill, is there's nothing in their background that suggests they would try to take the commission and intellectual property on a different path than it has been. I don't think they're going to do anything different. One of the things I've really enjoyed about the intellectual property, in my understanding, is, you know, society is very contentious today, but there doesn't seem to be a Republican or Democratic position on intellectual property law. If you're really cynical, you say that's because it takes a lot of thinking to work in intellectual property law, and so Republicans and Democrats avoid it like there's a rattlesnake. I'm not quite that cynical, but I wouldn't bet against it either. But generally speaking, there aren't positions. So when the commissioners are working on things and so on, they're generally trying to get it correct. They're not specialists. I mentioned none of them are IP specialists at all. And there isn't a Democratic Republican position, so they can actually try to be neutral on it and get the right answer. And so I never saw in the years I was there, 10 years, on a bench where the commissions were fighting over what appeared to be a political position. So in that sense, it's very refreshing, particularly if you're in Washington, because it's kind of like an island of sanity and the sea of sanity, because I like those people. So anyway, we have 5 commissioners. We're down 1 Republican. God knows when we'll get it. The place where we do see some politics is trade policy, because there generally is a difference between anti-dumping positions by Republicans and Democrats. You'll see the commissioners dissenting and fighting more in trade policy. Doesn't affect me, so I never cared. Now, I want to touch on this briefly. If the president did want to have an influence on that, he might do it here. When an ITC case is concluded, and they have found an exclusion order, that is, products will be denied interest in the United States, the president has 60 days to overturn that decision. He can do so for any reason he wants, basically. And generally speaking, that means his authority is only to overrule an exclusion. So there has to be an infringement, there has to be validity, and generally speaking, this president, as much as he's talked about IP and patents and so forth, has been strongly pro-American, pro-patent in his speech. Mr. Leitinger is the same. He's a trade representative. And the trade representative is the person who actually makes the decision to overrule an exclusion order. It hadn't happened for some 20 years until the Obama administration, and we thought it was almost dead. And then we had Samsung versus Apple at the ITC, and lo and behold, the dead thing walked up and started dancing on us. But that was a case that was very unusual. It's only been used 3 or 4 times in the history of the ITC, and we don't expect it to happen a lot because there seemed to be in this administration strong favor in trade for U.S. policies and that. It's unlikely they'll overturn exclusion orders very often, if at all. What happens is if we issue an exclusion order, it goes into effect, there can still be importation of the product that has been found to be infringing and imported. And if they import it, it can be with a bond. We can talk about that later. But the president has 60 days. Normally what happens is they do nothing, and after 60 days, then the exclusion order stands. They don't rush it or carry it, so it just expires, as a general rule. Meanwhile, there can be an appeal that's going on at the same time. Okay. This has been part of what was going on when I was a judge on the bench. The ITC, I want to emphasize, has 3 different rules. There are 3 different rulings they can come up with. There is what's called a limited exclusion order. And the limited exclusion order applies to named respondents. So let's just say we're dealing with telephones. I'm pulling this out of the air. Let's say Apple sues. And they sue LG phones. And they sue Samsung HTC, whoever else makes phones. They will then ask for a limited exclusion order because it will apply only to those companies that are named in the suit. And when they win on something like that, they obtain a limited exclusion order. And the reason it works that way is, generally speaking, if you're making a cell phone, you've got $1 billion factory somewhere. We know where it is. We know your address. We know who you are. So you get a limited exclusion order in those circumstances. Just think, it's easy to find them. They're a big company. You get a limited exclusion order. Now, what happens if there's a very difficult time in determining who the respondents are? And I'll give you an example. A case I had involved making rubber gloves. And you need to make rubber gloves, for those of you looking for a side business. You need a barrel with a rubber goop. You need a hand mold. And you need an oven. So you have a barrel, you've got this, and you've got an oven. You look, and you're making gloves. So you can start your glove company. And when we name you as a respondent, you sell it all to your neighbor here. He has his now, and you sell their oven to or whatever. And then if we catch him, he says to her. So basically, you don't know the company that's making it. It's hard to find them, easy for them to switch over. We've had cases that said the gloves was mine, so that's my favorite. There was a time, those of you that were small children a while back, or have small children, they made these little rubber band or wrist bracelet kinds of things. And there's a patent on that, believe it or not. It's a valid patent. But it's real easy for you to start a competing rubber band wrist thing because you have this little, a frame, and you have rubber bands and a set of instructions, and you're in business. Usually a box too. So it's very hard to find out who's doing it. So in that case, if you can demonstrate it's easy to do, it's difficult to find them, and so forth, you get what's called a general exclusion order. It's a very powerful tool because we won't stop companies from shipping their products. We stop products. So if you've never heard of this case, you're very happy in your company. Sorry to pick on you, but you're right there. So you're very happy. You've never heard of the ITC, you've never heard of a case, you're making your box of stuff and shipping it. It's stopped at the border. You go, what are you doing? General exclusion order. Everything that's a rubber glove or this wristband thing is stopped at the border. Doesn't matter who made it, where it's made, whatever. We're stopping the product because it's a general exclusion order. Very powerful tool if you can get it. Very hard to get now because there aren't that many products that are that easy to make and that easy to move. Now the last thing, say, okay, respondents are going to get away from the ITC because they're going to import a whole warehouse full of stuff before the orders issued, whatever it is. We're going to import 1 billion of these things, so no matter what happens, we're good. Well, we have what's called a cease and desist order, and that can freeze products that have already entered the United States. They can be shipped back out of the United States, but they cannot be sold, put into stores, anything of that nature. So 3 orders: general exclusion order, limited exclusion order, and cease and desist order. And that's what the judge can do. And they're a very powerful tool because right now, and in the phone wars in particular, I used to ask people this, but I've gotten tired. But generally speaking, they said in several cases, you keep your cell phone for about 6 to 8 months because the new models come out, they got new features and everybody likes the new and cool and designer color, whatever it is. So it doesn't matter your patent's worth 20 years because you're going to buy a new phone every 8 months. So stopping those at the border can be very important to protect your intellectual property because what you're making now to protect, you don't care about a year from now. So we function very quickly. We'll go through that, but stopping products quickly and effectively was more important than even money damages because you want to protect your market share, you want to protect your brand integrity. So the ITC in those days became very, very important in the overall scheme of protecting intellectual property. The last thing I want to talk about, we had a bunch of people, a lot of them were the intellectuals, professors and so forth, who have nothing better to do with their time, that said, well, all they can do is exclude products. If there is a standard-setting organization, then people who belong to that organization will declare their patents might read on the standard. Might read. They never declared something to be a standard essential patent. Take one thing away from it, don't ever say something is standard essential patent. And you have to license it on fair, reasonable, and non-discriminatory terms, generally speaking. So they said if a complainant has a patent that is subject to all this, they shouldn't get an exclusion order. And I had, the FTC wrote me a letter. Actually, they wrote me 2 letters, one from the chairman and one from the other 2 members of the commission. And the chairman said that I shouldn't do an exclusion order unless the complainant had proven that they had made a friend offer the other side. Now, anybody here ever take evidence law in law school at all? Well, the burden of proof on evidence is on the party that's proposing it. So she was asking me to change the law entirely. At least this is what I said in my reply to her letter. And I said, you probably don't want Essex to be the authority of changing law when he feels so. I think it might be a good idea, but generally speaking, the rest of the world's probably not going to like it. And the other 2 members of the FTC said that they preferred an evidence-based approach. And what we found here, and I don't know the reason for this, I have a speculation, but we've had about 12 cases that involve potentially standard essential patents. One was Apple versus Samsung. In that case, it was different than the other 11 because they both said the patent was in fact standard essential, so they agreed. And it went up through, and that's the case that the Federal Trade Commission, not the Federal Trade Commission, but the trade representative overruled the exclusion order. He said that Samsung could not have one against Apple under those facts. The other cases, interestingly enough, in the hearings, as far as I know, and remember, if it wasn't my case, I do not know what the confidential business information was, so I'm speculating, but probably I'm accurate. And that was, the complainants did not want to assert that their patent was in fact standard essential, because to do so would admit that they would take money damages and they might not get their exclusion order. So they never submitted evidence on standard essentiality. Respondents, they didn't want to admit the patent was valid, did they? And they didn't want to fight it on those terms. So the respondents never presented evidence on it being a standard essential patent. As a result, in the other 11 cases, the 2 sides fought it out without ever presenting evidence to the judge. Now remember, as much as I want to control the world and that, I still need evidence. A little quirk in the judicial system, the judges can't make stuff up. It's very limiting. But so we've had 11 or so cases involving standard setting organizations and patents that may be subject. Neither side, as far as I know, has been willing to present evidence because the respondents want to find the patent invalid or their products uninfringed. Because the fact that you declare your patent might read on a standard does not mean that it does. And by and large, most of the patents have been found to either be invalid or not read on the patent. We haven't found one that was valid and caused an infringement on the product. So we've had this large photo roll, I call it, on standard essential patents, standard setting organizations. We've had academics emptying barrels of ink at us. And we've never had a problem in any case with dealing with it. And we've been upheld at every one of those cases by the Court of Appeals for Federal Circuit that it wasn't appropriate form. So it's been the Shakespeare's play of habit, much ado about nothing. And I believe that the reason it's been that way is what I just said, that neither party wants to raise the issue because there's much to lose if they do. So they try it as an ordinary patent case. We judge them as ordinary patent cases, and they go up and we get approved. DOJ and the PTO, they wrote a letter, and it's funny, I had probably 3 of these cases. I had some of the first ones. And they would send these letters because the commission, part of my making the initial determination is we get input from other agencies, or if you have a lot of free time, you could actually write a letter and ask us to consider it, and we would put it in the file. So DOJ asked us to pay particular care to make sure that there wasn't a patent holdup or there wasn't a problem, so forth. So I put my opinion. I've read the letter from DOJ, and I am paying particular care that none of this is happening. By the way, it's not. Thanks for writing. More or less, I was fairly dismissive, and I got away with it every time. But, and the FTC, they wrote more than the other agencies because they have that kind of time. And by the way, the woman who's the chairperson of the FTC is now in my law firm, and she's on a different floor, and we agreed never to meet. But she's the one who wanted me to change the rules on evidence, that to require the other side to prove that this was not subject to FRAN, and I said, they probably don't want me to start rewriting the law. Why, I don't know. I'd be a good person to rewrite the law, but they didn't. So I ignored her completely. She was apparently in a fight with the other two members of the commission because they wrote a letter to dispute her letter. And I did not comment on that because I thought it looked bad. I said, by the way, you should listen to the other members of your own damn commission. That may not have been judicious, and I was on the bench after all. So, didn't write it, but it's not been a problem. So we've had this whole, I don't know, cycle of comments about standard setting organization, FRAN, RAND, and it's never been a problem. But since I had to deal with it, you have to listen to me. Okay, and this just goes into some of the cases. The cases Sony and Apple was the 794 case. The fascinating thing about this case, and I mean that sincerely, because I read the briefings and that, and you can go to public briefings. Those of you who are really interested in this law, I recommend you read Apple's brief, because in Apple's brief they said, by the way, Sony has declared overall in all the places we're fighting in, 28 patents, stands are essential. We beat them on 26. You know, their portfolio is not worth hardly anything, and they're certainly not really standard essential. So we're not going to take a license from them unless we lose all the way to the Supreme Court. And if we've lost everything and we have no other appeal, this is in the brief, you can look it up as they say, then if we have no other appeal, nothing else, then we want to negotiate a license and we want FRAN terms. Now, the reason I say that, for those of you who are familiar with standard essential patents and what's supposed to happen, all the agencies, all the standard setting organizations say, this is a rate that's negotiated between a willing licensee and a willing licensor. That's what a FRAN. Now, if Apple says, we will never take a license until the Supreme Court has shut us out and we have no other possible way of getting around this, are they still a willing licensee? Are they entitled to a FRAN rate? And there's nothing in any standard setting organization that says yes, you know, that you have to give it even if they're obstinate and cost you all this money, all the way to the Supreme Court. And I just propose this to groups I've talked to. If there's still a willing licensee entitled to a FRAN rate, what would make somebody unwilling? You know, somebody's actively hiring shooters to go to Samsung headquarters. You know, what would be unwillingness under these circumstances? I don't know. But right now, that's one of the problems with this whole regime, and it's something we had to deal with. The other ones, all these other cases I mentioned, nobody raised the FRAN rate. You can look at these cases and that, but they come to the ITC. There's a lot of publicity about this, whether it's appropriate, and we deal with the case and it's upheld, and nobody, you know, the courts have upheld us all the way through. And these are some of the things that I pointed out in opinions that have been pointed out by others as well, but there is nothing in the law that governs the ITC that distinguishes what a standard central patent says we should do something different. And obviously, for what the judge or the commission is supposed to do, they have to consider the law and not just what academics put in law journals. And I point out that this doesn't come up because neither side really wants it to come up. So far, so good. This 1613 case was a case that was eventually mine. It was a case of another judge's who passed away. And the respondents raised FRAN, or at least they said those initials in front of me, but they never presented any evidence. They go like, this is subject to a FRAN rate. Really? Why? Never mind. And they presented no evidence, so yeah, I didn't care, and that was the approach that I did. And that has been followed by the other judges, and the same things happen. And again, I don't know how much you've read or done anything about standard setting organizations or standard central patents. It's a big topic right now. It's a worldwide topic. Not only do the U.S. courts mess this up, but courts in England have messed this up. Courts in China are still wrestling with it. So this is a big deal. And what we did at the ITC is consistent with what's happening around the United States. Like in the Erickson D-Link, it was raised, but the court found that they had to present evidence. You couldn't just say Fran and therefore not get any. Motorola, the judge set a Fran rate. But all this has been cases where the judges had to consider evidence that was presented. Your own Jim Holderman here in Novato Ventures. There's a case about the interesting thing about these first two cases, Microsoft and Novato. And I'm lecturing a little bit on district court, but I could do so. And the parties allowed the judge to do just basically like an arbitration. They waived jury and just let the judge do what they wanted to. Your own James Holderman had a great time with that. And it's what we have done has been consistent with what's happened other places. Other things, the complaints have tried to get early disposition and some other things, none of which has been done. So let's jump a little bit because I see I'm running out of time. Interesting thing about the ITC, that no other court in the world I know does this, but in Tenru Group, there was an American company that made railway wheels, and they had two processes by which they used. One was called the Griffin, and one was the ABC process. They were using ABC in China, and they couldn't get a license with this company, so Tenru hired away all the company's top executives, and they built a plant that was exactly like the one that they'd been wearing before. Oddly enough, these workers carried with them blueprints of the factory and everything else. But it was all that this was done. The theft of trade secrets was not disputed at the hearing. But they did say, this is all done in China, you have no jurisdiction. And we said, well, we're not going to stop you from making railway wheels. We can't do that, you're right. But we can stop you from importing them because you violated a U.S. trade secret. It's an unfair trade practice to do so. You're hurting U.S. industry, and they don't come in. And the Chinese were outraged, and they appealed, and the Court of Appeals said that is correct. That even though the theft and the unfair practice occurred in China, we have a right to stop them from coming to the United States. The Chinese were particularly upset. They had this other case, Sino Legends, same basic principle, is all in China and so forth, but this was different in that after the appeal, they did ask for certiorari to the U.S. Supreme Court, and the Chinese government filed a brief to the Supreme Court saying, sovereignty, China, what all they say, and the court denied it. So this is the law, that a theft of trade secrets occurs extraterritorially outside the United States, can result in an ITC case, and if proven, can result in an exclusion order. No district court can do anything about this, really. So we're the only game in town. We are seeing an uptick in trade secret cases. There's one going on right now. Then we're seeing more of those. Okay, domestic industry. Domestic industry, I mentioned, is very easy with plant and equipment, capital and labor. Licensing used to be simple. Licensing was a lot of fun because you say, okay, let's take a company, InterDigital, and they do research and things at the 4G, 5G, all that. And they had 4 or 5 licensed sellers, basically. They had a very nice title form. It wasn't licensed seller. That's what it did. They said, we got 5 guys doing this, $3 million in salary, or whatever it was. We make $500 million in licensing fees. That's our domestic industry. Well, in the 613 case, the Court of Appeals said there has to be an article associated with licensing. And an article has to practice a patent. There's an argument. My good friend Judge Newman said the article has to be made in the United States. she said that in dissent because the court said it did not. It could be made in a foreign country. I had a case going on at the time when they did that, and it was Microsoft, and I've never felt sorry for Microsoft before, but discovery had closed. Microsoft hadn't proven that their source code was used in these imported phones, but those phones had become their domestic industry. And they had no evidence. And the judge was a mean old bugger. I said, well, if you have no evidence, you lose. The burden is on you. You didn't do it because, hell, you didn't have that requirement 2 months ago. So now you have to have an article associated with licensing. And that has changed it considerably. Interestingly enough, this case, the 613 case I mentioned, they proved domestic industry in the same old way. We got 5 people working in this room, it's 1,000 square feet, they make so much salary, we did. That way of proving domestic industry was approved by Court of Appeals Federal Circuit. So now they have this licensing thing out there, but the old way has also been approved by courts. So they're going to have to reconcile at some point. I don't know exactly when they're going to be able to do that. And the ITC, the commission has said, you can't also, this is another ruling of commission, generally they put this in to fight non-practicing entities or patent trolls. And they said you can't just license a portfolio, which is what everybody does. No one in the world goes license by license. It is a major corporation. They have, Samsung's got 20-some thousand patents in that portfolio. Apple's like, IBM has more. And they just want you to go away, so they'll say, okay, you take a portfolio license. Well, that's not good enough. The ITC now, they want this particular patent. The asserted patent has to show domestic industry. No one did that in the world. But the people up on the 7th floor were thinking real hard. And they decided they were going to require that. And they asked these other questions of the base or pioneering patent. I don't know what that means exactly, but apparently it's important if you got it. Does the market recognize the value in some other ways? Anyone that can tell me what that means, I want you to come up to me at the end of this lecture and enlighten me. I'll buy your beer or whatever, because no one knows what that means. So they listed 39 factors that the commission wanted us to consider. They gave us no guidance on the weight of them. So if you have 10 of them, is that enough? If you have just one that's real heavy, is that enough? And we don't know. The problem that has been for the judges and others, and for many corporations thinking using the ITC, is you basically don't know if you have to rely on licensing if you can be at the ITC till after the commissioners rule on your case. So, costs about how much to come to the ITC? Everything costs more than $1 million? I'd put my hand up for more than $5 million? Yeah. So they're wanting to know if they should spend this money, and you go, I don't know. You might have it. We'll know at the end after we spend all the money. And that's one of the reasons you've seen the figure drop a little bit. I did a list of 39 factors. One of the attorneys on the 7th floor told me, quote, that I was on my high horse about this, and she didn't think I was correct. I said, well, that's wonderful. Tomorrow you're on a panel discussing this. I want to hear why you think I'm wrong. She said nothing. So she said, this isn't right, but I'm not going to tell you what's right. So this is another thing. It's somewhat unique to the ITC. We're going very quickly, but even if there is valid intellectual property patent, infringement, importation, domestic industry, if it is not in the public interest to give an exclusion order, we don't do it. This comes up every now and then. I think 3 times it's come up directly, and the 4th time it's come up indirectly. And basically, if these factors, if they are in play, and I give you the best example, if the health, public safety, welfare concerns, they can. We had a case. It was a bizarre case, but there was a company that had a patent on burn beds for burn victims, and it had airflow, and these that will basically stop the skin from chafing. So picture burn victims who are in great pain. Well, they had a patent. They were selling all the ones they could, but they didn't want anybody else to make a burn bed. And they admitted they weren't going to make more, so basically you're going to have a certain percentage of all your burn victims writhing on a bed that doesn't have to be in pain, and so they did not enforce the exclusion order. Now, why the company wanted to go to the ITC and get one, I don't know. because the facts are they admitted they were not going to make more, and that. But so we did not use the exclusion order. It's been done 3 times. At least 2 of them are in national interest. One was a case that involved getting better gas mileage in cars during the Carter administration. He was a past president. They ruled that if they did exclusion, then we'd run out of gasoline. By now we'd all be walking. He was as right about that as he was many other things in the administration. Come see me afterwards if you want to hear a grumpy old man. The other case involved centrifuges and nuclear material. Let's just suffice to say the U.S. military is real interested in this and did not want these things excluded, and they were not. This has come up partly in a case we had one case where exclusion order that was involved walkie-talkies for first responders, police, firemen, ambulance, what have you. And they came in, they did a marvelous job. They came to the commission and said, people will be shot, crime will shoot up, fires will burn down to the ground, people will die waiting for ambulances if we don't have these walkie-talkies. So the commission did not exclude the exclusion order, but they suspended it for 12 months and allowed spare parts to come in. So basically, they still had an exclusion order, but it didn't really exclude anything. And so this is still in play. It can still be used, but it's going to be very rarely that the public interest, because oftentimes respondents have made the argument it's never in the public interest to exclude something because prices will go up. And that argument loses every time. They say, yes, that's part of it. If you can't infringe all patents, then prices will go up. That's the nature of it. And so they were supportive, and that argument never wins, don't make it. All right. Again, the problem in domestic industry, this is the statute itself, and it's very, very badly written. Substantial investment in its exploitation, including engineers' research, development, licensing. Everybody know what "its" means? It does not fit with the first two. I'll tell you that grammatically, this makes no sense. "Its" means patent. Substantial investment in patent exploitation, including engineers' doesn't fit. It was added later on because of a movie called Gremlins. And Warner Brothers had a copyright on these cute little plush gremlin toys, but they made them in Taiwan. And so a bunch of knockoffs were being made, as happens. They came to the ITC and said, look, this is an American movie. We made it in California. American copyright. Got that in California. And we said, but the little creatures are Taiwanese, not American, and we're not going to give you a remedy. And we didn't. And so Hollywood came to Washington, D.C., and they added C, and nobody knows what the hell it means now, exactly. If you have a patent, and you have these other things, you can meet the requirement. Substantial investment. No one knows what substantial means exactly. It means different things for a very large company, I can tell you that. It means different if you're a little garage mechanic. But what it means exactly, nobody knows. And we're still struggling with it to this day. All right. This is one of my favorite slides. I am self-pitying in this slide, I will admit it. This is our timeline. This is why people like our district courts. District courts, the fastest ones I know take about 3 years to resolve all these cases. You come to the ITC. That's right. We'll take you in. We'll get you in on this day. We'll get you out right now on average 16 months. No fuss, no wait. 6-month period for discovery. That includes foreign countries. That includes trying to find one in Japan where you have to reserve a room in the embassy because the Japanese won't let you do it. Boom. 6 months there. We do the hearing. Judge has 60 days. Goes up to the commission. They say they take 60 days, but they grant themselves liberal extensions. I was on a committee, and they were trying to say, how do we make sure we don't expand how long it takes? Speed is our essence. And I said, well, who's getting into the delays? God, they hated me for that. Because they didn't want you to. I said, well, let's not try to find fault. We'll just do that. So went downstairs and pulled the statistics. The next meeting I had them, and I'm retired now. So, but I want you to look at this and think of the speed. If any of you tried cases before and so on, this is ungodly how fast this moves compared to other cases. And if you have companies in taking evidence in Japan, Korea, China. To try to get all this done in 6 months, you have planned. This is one of the advantages to be a complainant, because if you're a smart complainant, and I know your students here, Daryl's teaching you, I'm on your advisory board, for God's sakes, plan, please. The complainant should have their case all ready to go when they file it. And a respondent sitting somewhere halfway around the world, fat, dumb, and happy, has no idea, and boom, it hits them. They've got to respond in 10 days. And they already, when we file our complaint, we're filing discovery. We've got the interrogatories written, ready to go. We know who we're going to depose, and you can dang the hell out of your opponent. So that's the more important thing. We'll skip the conflicts, PTAB and that for another day. Daryl, you said we've got enough lecture in them for one.
We can continue in the Q&A segment.
All right, well, let's go with the any questions part here. So thank you very much. I appreciate you listening.
Thank you.
All right, I'll hang up.
Where's Kyle? Are you helping? Emily, are you helping?
Yes, ma'am.
Okay, so we're going to go into time of Q&A. We're testing something out, as Carl mentioned earlier. It's called pigeonhole. So what I'd like you to do, if you have any questions for the judge, is to use the app. And Carl, do you have it up? Okay. And how do they get more questions up there if they want to?
If you right down the screen, there's www.pigeonhole.at. If you go there, you type in the code 1015 and you can type in more questions.
Okay.
You don't need to log in, right?
Great. So you can see the questions, and then the rest of the folks here can vote for your question. So it's a little bit like Facebook. You can click a like on it, and then if your questions get revoked, then they will be top of the list.
Well, and I want to congratulate the people giving up the first question, because I can actually answer it. That's good. The process runs fast. It was statutorily designed to run quickly. Again, we started out as a tariff statute that the president ruled on. They changed it. And when they changed it, they made it statutory that we would complete an investigation within 12 months, 18 months in a more complicated case. That was specifically in the language. And that stood for a long time. And then does anybody here remember the GATT? What the GATT stands for? The Treaty on Treaty and Tariffs and that. But under GATT, you have to treat foreign companies the same way you treat U.S. companies. And a complaint was filed by one of the extremely hostile countries in the world, Canada. And a Canadian complaint said basically that it's not fair because a foreign country can be in the ITC and a district court at the same time, and all the remedies are not available. And we said, okay. So, and we didn't get into all the detailed statute, but now if the respondents have a right to suspend action in any district court case until the ITC case is run, and they have a right to raise defenses against the complaint, but those will be sent to the district court for that. Also, and that satisfied the people of the GATT, and so we basically, at that same time, pardon me, I left out, they also complained about the speed and saying it's statutory and there's no statutory limit on district courts, and in fact they run slower. So we said, okay, we'll remove the statutory requirement 12 months and 18 months. But when they did that, because the mentality of the ITC has always been do it fast, we kept that mentality. And there is no statutory requirement, but we try to hit those times. And it's one of the reasons people come to us, so I don't think we will lose that. There's no statutory reason. We have extended, some cases were very complicated, more than 18 months, but very seldom.
You know, one contemporary issue that we see a lot in the news is this trade war between China and the US. And one of the things we hear the president saying a lot is China stealing our intellectual property rights. And the ITC is supposed to be this border guard that protects against importation of infringing products. Now, does it surprise you that we don't see more of such cases brought against Chinese companies under this current administration?
Well, it doesn't surprise me necessarily. First, I was surprised when we were able to enforce the theft of trade secrets that occurred on Chinese soil. That was, no one saw that coming, to be frank. So that was very interesting. What the president says, and I don't, you know, as I always tell people, it's one thing to make a statement, it's another thing to provide evidence in the form of hearing, which I'm used to. If we had the right case and there was alleged theft, then that would be a defense that could be raised. If a Chinese company was complainant, we don't see that often. When the Chinese companies are respondents, they're charging infringement anyway, so the actual, whether it's theft or whether it's just infringement, hasn't come up a lot. So the ITC wouldn't be the forum to address those issues. So I'm not surprised. What is the cost of ITC proceedings? I had a question. And what's the biggest driver of the cost? We are, the attorneys. We charge a heck of a lot. The actual answer, and not to be terribly serious about it, but the actual answer is, according to the AIPLA Economic Survey, which is the only place I can get decent economic results, is the cost overall is about the same as district court, and this is $5 million in a large patent infringement case, about the same as district court. But if you're at the ITC, you've got to cough that money up within 16 months. The general rule, that's how fast it goes. In district court, you have leisure. You can raise it. You can let interest work on your behalf, because they take 3 years to 5 years to finish a case. If they ever finish it, they have cases that go to trial. About 3%, as I mentioned earlier. So you can spread the cost out more. It's not actually a greater cost at the ITC, but it's very compact. You end up paying it all a lot. And in district court, most of the cases settle, so I'm assuming there's some savings involved with that. So it's about the same if you look at it in the total cost of defending your IP, but you incur it all in a quicker period of time, and that's the problem. Oh, I was about to elaborate on conflicts between. Now, the conflict's more procedural substantive. The second part of your question is the answer is no, and the PTAB is also designed to move fast. And when they set that up, I actually worked with James Smith to try to make it fast. The problem is this.
Many of the people in this room probably don't know who James Smith is. So what
He was the initial chief judge of the PTAB, and he helped set up the procedures. They followed the ITC for procedures for going fast. That's how that worked. But the main conflict is this, and again, one of my cases to illustrate, I found a patent valid and infringed. The PTAB found the patent invalid, and the party came trotting to the ITC, very happy look on their face, and said, "Look, the patent's invalid." And we said, that's not a final decision. A PTAB decision is only final when the Court of Appeals Federal Circuit has ruled on it. Now, Patent Law 101, Darryl will get this question right. Patents are assumed to be valid, be invalid. Until the court's rule, they are valid. So we said that's a valid patent. I don't care what the PTAB said. It's now got to go through the appellate process. So we're going to enforce the exclusion order. Thanks for playing the game. Get out. We were probably more polite than that. But that was the essence of the conflict, is that they would move quickly and find the patent invalid. We found the patent valid, and they'd have to wait until the Court of Appeals. Now, this isn't our fault, because the Court of Appeals approved that process. They said, yes, those are not final decisions till we say so. They're like umpires. It's not a ball or strike till they call it. And we were willing to enforce our judgments because we were supposed to move fast. We were very reluctant to give any stays. The conflicts would be resolved to reach consistency. Either the Congress or the Court of Appeals Federal Circuit would have to change the law, I think, to reach consistency. And remember, consistency is not such a big deal. Lawyers get paid when they're inconsistent verdicts, so I don't think they will be resolved in the short term. There was a case that stayed the ITC opinion, waiting for the result of PTAB, but in that case, both parties agreed to stay, which I don't know why they did that, but they did. So there has been a little movement, but I don't know that it will go far. So that's the best answer I can give you.
Okay, but before we go to the next question, as the questions keep percolating, I think many people in this room would be curious as to how you became an ITC judge, and what is it? The title of this is an insider's view. So, what is it about the ITC that you found surprising as an insider?
It's an insider. The path no one should study my career as a path to anything, because I got really like a big phone call. I came out of the U.S. Air Force, and I wanted to become an administrative law judge, so I applied. I got accepted. The ITC will not hire brand new administrative law judges to do these cases, so you have to go to either Medicare or Social Security first. I did a year there. The ITC had an opening. I had a good background in just examining. I did accident investigation for the Air Force, plane accidents, so I could break down arguments and so forth. The way the process worked is all 6 commissioners sat in the room and with the secretary and interviewed you. I apparently did well enough because they offered me the job. I took the job, and that's how I became one. The insider, the thing that I guess is most impressive is these are very, very complex cases. In patent law, certainty is a commodity that is very much in short supply. So you had to basically get used to giving your best shot, and you couldn't take it personally if you were overturned by the commissioner or you were overturned by the Court of Appeals, because and to give you whatever comfort you could have in other people's misery, the Court of Appeals got overturned by the Supreme Court more often than I ever got overturned. So, the people who are supposedly the greatest experts in the country weren't getting it right. So you had to develop kind of a thick skin about it. As a judge, the most important thing I'd say is you learn to lay out the record very, very clearly so that the commissioners and the Court of Appeals Federal Circuit could use what you had done to make a sound ruling and have the evidence. Even if they disagreed with you, you had given them everything, and that was important. And then you learned to take pride in the quality of the work you sent up there. Whether they agreed with your conclusion became far less important than just being satisfied that you'd done everything you could and that you gotten the right issues in front of them.
I see that one of the questions is trending, as they say already. So why don't we take that question, Judge?
Well, I'll tell you a funny story about this. The first time I went over to Korea, I was at the Korean Electronics Association. And I was giving a lecture, similar to the one we did here, only I got more time. Well, the Koreans are very patient people. They put up with me about 3 times this year, so they're very patient people. And there was an attorney who was head of LG Electronics. And he was very proud that year because they had 5 ITC cases. He had all the slides in that. And he pointed out they'd won 3 outright. The 4th one had kind of settled or just gone away. He didn't say. And the fifth one was, I think, on appeal. He was very proud they'd won, 3 out of 4 basically. So I got up and did my lecture next, and question time came, and there was always the young men who cast in the back with their, they want to challenge authority. You are the United States International Trade Commission. How can you be fair? I said, weren't you listening to the last guy? He said they won 3 out of 4. He was real proud of us. And then I went on to talk, but we are an American agency. Do foreign parties worry? Yes, and that's one of the reasons that we bring them. And I actually brought the Korean Supreme Court judge and the regional judge. I let them question everybody in every part of the agency up and down, and actually see part of a hearing. We got the parties to waive confidentiality by basically twisting their arms, but nonetheless. And after a full day, they both said that they had a lot of their fears and thoughts of bias alleviated by actually seeing, talking to everybody, and so on. And I think that's a constant thing that the ITC should do. And the trouble, and the main reason I tell people, it is very difficult. Patent interpretation, claim interpretation is very difficult. And, I'd like to think I've had a good education. I like to think I'm not one of the dumbest people in the world. But for me to be smart enough to intentionally put my thumb on the scale of claim interpretation and write an opinion that not only would favor the wrong party, for patriot's sake, but would get past the 6 commissioners and then past the Court of Appeals for Federal Circuit. I'm not smart enough to do that, frankly. And I wouldn't, and just getting it laid out and listing all the factors, it is enough intellectual challenge to do that and do it honestly, that it would be very difficult. That's the first thing. The second thing is, I've known some of the judges are now retired, several of us, and I know the current judges, except I've not met Judge Elliott, but most of these people have a great sense of internal integrity, and I cannot imagine a judge that would want to try to cheat and want to try to do that, and then would have the ability to do it. So I wouldn't worry about that personally. I don't think it will, you would ever see it. I don't know. You'd have to be awfully intelligent to figure out how you could give the wrong claim interpretation just to favor, say, the United States, and make it all make sense. I just cannot imagine being able to do that. I certainly couldn't. I don't think any of the other judges could either. So that's the short answer.
One follow-up question to that is, you've been to all these different countries around the world, and one thing I notice when I travel is that you have jurisdictions increasingly trying to replicate what the U.S. has in terms of specialized IP courts.
Well,
do you see these jurisdictions also trying to replicate the ITC system?
Korea has. China's very interested in it. I know I travel at least once every year with former retired Chief Judge Randy Rader, and we go to China and we do a lot of exchange of ideas and that. So there is a lot of interest, and there's a lot of interest in trying to get things right, figure a better way to do it. So I don't know that they'll develop something exactly like the ITC, but they're very curious in our speed. They tend to like it because no foreign country, with the exception of England, really understands the American jury system. England's abandoned it for IP cases, as you know, so we're the only ones that have a jury. Go over to some foreign country and start trying to explain the jury system. Well, see, we're going to have 12 people do this and make decisions. Okay. So there'll be specialists, engineers, and that? No, they can't be specialists at all. They can't know anything. Okay, they can't know anything. So they're like judges, they're learned in law. Oh, no, they can't know anything about the law either. So where do you get the voters list? And about that time, they just click off and run. The ITC is more interesting to them because they have co-specialty judges.
Right.
And so that is something the Japanese are fairly familiar with, the Chinese experience that. So they actually have more of an understanding of ITC than district courts. I mentioned Hollywood working to change ITC rules.
I knew somebody who asked a grumbling question.
Oh, yes. Every industry that ever got sent to the ITC has lobbyists. Washington's lousy with lobbyists. You wander down the streets and just look at names of buildings and you see there's actually a Salty Snack Association that does lobbying, apparently. Not in the ITC, but other places. Gremlins was a particular case that was important to Hollywood because a lot of times, if you look at movies like Batman series, Gremlins, others, there's more money to be made on selling the little figurines and cars, and in this case, the little furry gremlin figures, than an actual making of the movie. So Hollywood has a very effective lobby. There's an old expression that Congress in D.C. is Hollywood for ugly people. And the lobbyist for Hollywood had great influence. I can't remember the name at the time, but he had great influence there. So they were more effective, I think. But other industries, again, I mentioned there was a lot of the companies that were in standard-setting organizations were trying to get the ITC cut out of that. If it was an alleged standard central patent, they're trying to get cut out. So you generally have two large bodies in IP law. One is the electronics and manufacturing, the other is pharma. We do not do many pharma cases because there's a whole procedure. It's called the Orange Book. I don't know anything about it because they don't file at the ITC, but the other electronic lobbyists are constantly trying to find some sort of advantage. So it's going to continue. I don't think they will succeed in many of the changes that have been proposed, but they're constantly lobbying.
just a follow-up question to that, and then we'll take a live question, because I know not everybody is necessarily plugged into your smartphone. So if you don't have your smartphone and you do have a question, think of one that you want to ask, and we'll take one live question before we go to the pigeonhole questions. But we've been talking about patents so far at the ITC, and you touched a little bit about trade secrets. To what extent does the ITC also deal with, say, trademarks? And to people who are interested in things other than patents and trade secrets also think about the ITC?
Well, yeah, and we have had trademark cases, but they've been very, very uninteresting trademark cases. And I say that because the trademark cases I'm familiar with were just absolutely ripping off the original product. Same name, same little R in the corner. And those are, from a judge's standpoint, it's sort of like, look, we make this company made one exactly like ours, and that's the end of the case. There's no thinking involved at all. There had been another set of trademark cases, and that was called gray market goods, and that is many big corporations will make products to be sold in Europe, Asia, and the US, but there's differences in them. And so they don't want a product that's designed for Europe to come to the US because it may have different kind of glass in it, different regulations involving controls in that. So for that reason, trademark has not been interesting, because basically you have to protect the US from the importation of these gray market goods. And if the company allows this to happen, let's say Caterpillar allows the European tractors in, they lose the right to exclude them. So we get those cases, but it's just mathematical.
Any questions from the audience? Like live questions. Everybody's gone virtual now. Yeah. Okay.
You
Yes, sir.
mentioned anti-dumping. How does that figure into your talk?
Let me just repeat that question for.
All right.
So
Okay.
yeah. So the question is anti-dumping. How does that feature into your talk?
Well, the anti-dumping is under Title VII, U.S. Code, and the judges do not play a role at the ITC in it. That is the commissioner. And essentially, I'm not an expert on it, but there is a mathematical formula that basically, if they are selling goods for less in the home country than the goods that come in the United States can investigate the prices. There is, I think, an algorithm they can put the financial data in and determine whether it's an unfair predatory price in the United States. And the worry, I guess, is that if a company undersells us, U.S. versions of that company go out of business, and then they can jack the prices. So they figured that financial information, it can involve everything from tires has been in it, shrimp from Vietnam has been in it, which struck me as an odd thing to have an anti-dumping case in shrimp, but it was there. But that is done by the commission, and it's done by our PhD economists, and there's a formula, and either yes or no, and then what happens is the commission will recommend a tariff, and unless the president again can overrule that, the tariff will go into effect to try to make the price in the U.S. comparable to the price in the foreign country, and usually then we found that the countries will go into negotiations very quickly and talk about it, and that gets sorted out. But we don't have anything. They don't normally bring those cases in 337, so we don't have much to do with them. So I can't tell you much more than that. But that's what the anti-dumping is done by the commissioners, and it involves the economists, and they just take prices from the home country and our country, and it goes into the big machine, and it comes out yea or nay. Probably it's more complicated.
We're running out of time, so I see that there are two more questions. Why don't you take those two questions?
All right.
And then what's going to happen is we'll wrap things up, and we'll have like a 10-15 minute break. My class is here. You guys will go behind for the round table of the judge afterwards. And then the judge will be around for the rest of you. You're going to come up and say hi. I'm sure he'll be more than happy to talk to you. And then we'll go over in about 10-15 minutes. But why don't you finish these two?
I'll be more than happy for you.
All right.
All right. Future ITC policies going. Speaking of 337, I think they have to do something about domestic industry. I mentioned they have 39 factors. They don't know what the hell they are or how much they're weighed. That is a problem. They have tried to do a special 100-day program where they would take just one issue and have the judge decide the one issue. That has, in my opinion, remember you can't attribute this to anybody but me, but that's been a spectacular failure. I did the first case. I wrote and told them it's a spectacular failure. They didn't listen to me. So that'll change. Other than curing the domestic industry and trying to figure out what licensing really means and bring it into something where companies can know in advance whether they can go to the ITC or not, I don't think there'll be much change. Protecting the patent holders' rights. We're not the problem right now. The ITC generally tends to uphold patents. The PTAB is killing patents off at a rate of about 70-some. Judge Rader has called them the Patent Assassination Board.
That's squad.
That too. I heard assassination too. So I don't think we have been the problem with patent holder rights, but they've got to get that straightened out. I think the current chairman of the PTO is working very hard to get that straightened out. But right now, generally speaking, patent holders do better at the ITC than they do at the PTAB, and that's where most people's attention is focused on trying to cure this. Let's see the other question here. No, we haven't had those come up yet, although, you know, say 5G technology patents, Ericsson, Nokia, InterDigital, all those companies, whether it's 3, 4, or 5G, they're all the same kind of it. I think the 5G, the big battle right now, Qualcomm versus the FTC, and I think Unwired Planet, which is a British case, Judge Briss did some very interesting things in that case. So there isn't like a 5G patent. There's some new patents involving the wireless internet and so forth, and that some of them are 5G, maybe 4G, but they don't come this neatly defined. You know, we patent on a certain way of a base station communicating with a handset, and it might be 5G, but it wouldn't be identified that way to the judge, so we wouldn't necessarily know that.
All right. So at time, I think we were treated to a real comprehensive tour of the ITC, and a whole bunch of war stories, very vividly narrated. So please join me in thanking Judge Essex.
And once more, let me thank all of you for your time and attention. I greatly appreciate it.